Kelly to talk for about 10 minutes, 5 to 10 minutes. I don't know if we can pull up your amendment, Senator Brock. We don't have, I don't know if it was posted, and we don't have Damien here yet. Oh, yeah.
Well, unfortunately, as far as Damien has made some modifications from the draft that you have up right now. So I do think we need Damien to see those changes, and they specifically related to fraud and the prosecution issues associated with it. I'm not sure the draft that you have right now includes some limits, because we put a floor in so that we weren't going after looking for prosecution for minor de minimis issues.
Okay.
Want to make that clear.
Okay, good. Well, we don't have Damien probably for another 10 minutes, but in the meantime, we'll let Kelly testify, and then we have Cameron on hand, and we could. I'd like to finish up any discussion on fraud no later than 9. So, and we won't necessarily make a decision, but at least have that input. So, Kelly, welcome. I'm sorry about yesterday, and the floor is yours.
Thank you. Thank you very much for inviting me here. For the record, I'm Kelly Kazmarski. I'm a staff attorney at Vermont Legal Aid. I did submit a letter last evening that sort of represents our collective response or views on any sort of fraud prevention element or amendment to S10. We have an unemployment task force at Legal Aid, and I just want to acknowledge that I have several coworkers who are also involved in preparing this testimony. So I just want to acknowledge their help. But in general terms, as my letter points out, we worry about adding any sort of criminal penalties in the unemployment context. We already know that there are many collateral consequences from criminal records that haunt people for years and years. And among those are barriers to housing, employment. We've just seen it time and time again. And it's my understanding, and I'm sorry that I don't know specifically more about this history, but I believe I learned at some point that the legislature specifically decided in the past to take this issue of people who intentionally misrepresent or fail to disclose information to the department, take that type of an issue out of the criminal context. And I believe that there was a decision made that it should be decriminalized, and that was the reason why the penalty week provision had been implemented. So it seems sort of counterproductive to now go back to using criminal sanctions in a situation like this. It also seems to run counter to Vermont's general policies of, in the criminal justice system, for example, turning to restorative justice policies. So we would just, we would really oppose a measure to add a criminal penalty here. Again, I guess I would emphasize that it seems that there is an emphasis or at least a concern that, or maybe a disproportionate concern that applicants for benefits have some fraudulent intent, or that there is a large number of people out there who have fraudulent intent in seeking these benefits. And we really worry about approaching this entire problem with sort of an assumption that people are going to need a stick out there or else they will commit fraud. So I guess that's another big concern that we all have. if there is going to be a change to fraud detection or fraud prevention systems, it would be our recommendation that it be done in a more in a slower process involving the Attorney General's office, for example, involving workers' rights groups, legal aid, to take some time to really consider collateral consequences, to consider long-term how this would impact Vermonters. And I guess finally, I would also, after listening to testimony yesterday from many business owners or lobbyists who represent various business interests, I want to be very clear in explaining that people do not have a choice about remaining on unemployment benefits or going back to work. That seemed to me to be sort of an underlying assumption in some of the testimony yesterday, that there is a need for threats or sticks about fraud, or perhaps this is a reason to not increase benefits because it would disincentivize people to look for work. It's simply not true that people can refuse work and stay on unemployment. I heard a few people testify yesterday suggesting that, if I had the choice to make more money on unemployment, I would choose that too. But that is a false narrative. It is not possible for someone to choose to stay on unemployment rather than accept an offer of suitable work. So I want to make that very clear for the committee. So I guess in closing, I would just say that we believe that there is enough in the existing system to handle the fraud that does exist. We acknowledge we're not naive. We know that there are certainly bad actors out there who are going to try to defraud the state no matter what the legislature does. There's no foolproof way to prevent that. We are concerned that adding a criminalization measure is going to catch people in that net who simply made mistakes. As I point out in my testimony, I would say almost 100% of the cases that have come into legal aid involving determinations that say that the claimant intentionally misrepresented or failed to disclose something to the department, those have been reversed on appeal because it's obvious to the administrative law judge that there was no intent here. So we are concerned about the effect on, many, many people. We see certainly hundreds of Vermonters every month dealing with legal issues, but there are so many people who never make it to legal aid. We believe we're just seeing the tip of the iceberg here. And so we would really urge you to not add a criminal penalty here in the fraud prevention. The commissioner certainly has the discretion in those egregious cases. We believe the statutes as they exist allow for prosecution. We heard lots of testimony last year, for example, of someone who defrauded the state of $100,000 in the unemployment program. I would say that's a huge anomaly, that most of the cases of involving alleged fraud involve far lower amounts of money. But there are existing methods for prosecuting people who engage in that kind of behavior. So I guess I want to reserve time for questions. As I said, my written testimony sort of summarizes everything I've just said, and I'm more than happy to answer any questions. Thank you.
So, Kelly, one of the things that I was struck by in your letter, because believe me, we've been dealing with administrative problems at the department all session long. Last session, a lot of very unfortunate situations, a lot of them caused by the pandemic, a lot of them caused by the mainframe.
Mm-hmm.
I was very struck by your comment, which I thought was wise, is are we going to put added burden in terms of tracking down fraud of the department that can have hearings for 3 months, delayed and all of that. Can you talk about your experience a little bit on that and with the department and where you see difficulties getting through or adjudicating cases already, that you have this fear that is this good? Is this going to take prioritization over more essential work, perhaps?
Right. I think that exactly. You've said it very well. I mean, fraud is certainly a serious issue. We don't mean to minimize the seriousness of that issue for the state. However, we do not think that that is the biggest problem that we currently have with the Vermont Department of Labor. As I said, our biggest concerns have to do with the waiting times for clients. We have many clients who they apply for benefits, they wait months for a determination, or they are in adjudications, they get a determination that says they are disqualified or denied for some reason, and then it takes months to get an appeal. I mentioned an example about a person that clearly seems to have a meritorious appeal. They have a doctor's note showing that they had COVID, which was the reason they couldn't get the doctor's note to the department on time. It seems obvious that's going to be dealt with on appeal, but she has to wait until the hearing to get that addressed. When people call the department, we are hearing time and time again, still, we know well, I guess I should say, we do sympathize. And certainly last year, we had no idea how the department was able to handle the crush of demand that it experienced. So we do understand that there are really good folks working extremely hard over at Labor, and we appreciate all their work. And we continue to have clients who say that they call and call and call, they can't get through, they get false information, they're told different things when they call. One client wrote down 5 different answers to the same question. So clearly the department has serious issues that we feel stem from 2 major problems. One being the mainframe, the technology it needs to be upgraded. It is appalling, the system that they are working with. It seems to me that the state and the department has known for a very long time that system needed to be upgraded. I know that there's quite a history in the work that went into trying to upgrade the system, and that fell through. But that should be a priority of the commissioner, of the legislature. That needs to be fixed. And so that needs to be adequately funded so that the department can upgrade its technology and its technology infrastructure as it needs to. And then the other piece is the staffing. They need more staff. They need better trained staff. The commissioner all but said so in a letter to legal aid. We wrote to the commissioner in January, emphasizing some of these points, and he did respond recently. And he himself pointed out that, they are working with the resources that they have, and he recognized that they could probably use more staff. It certainly seems some of the staff that they have could be much better trained. I have many examples of clients who've dealt with claims adjudicators who bullied them, harassed them, claims adjudicators who made big mistakes on these reports that come in. If you appeal a case, you get a copy of the claims adjudicator's notes. And it's amazing how incomplete some of those records are. It's inconsistent. Some claims adjudicators do a great job and are very thorough. It should be more consistent. So these are the things that we believe the commissioner and the legislature should be focused on. That is improving the technology infrastructure, increasing staff, training their staff better. These are the biggest problems over at Labor. Fraud is an issue that needs attention. We believe that the statutes as they exist allow for prosecution of those bad actors who are going to commit fraud no matter what you do. And we're hoping that efforts can be directed more to fix these more systemic problems that would certainly immediately impact not only claimants, but employers. I mean, that also has to be recognized, that improving the technology and improving the staffing is a way to improve the unemployment program for all Vermonters, workers and employers alike. I think everyone would agree to that.
Okay, does anybody have any questions for Kelly? Senator Brock.
Kelly, do you have any opinion or perspective as to if their laws are adequate, why we don't have fraud prosecutions?
My understanding, and again, it's rather limited, but I think that the reason there haven't been fraud prosecutions is because the department has been implementing the penalty week scheme that we saw last year. Remember, as the pandemic began, there were several Vermonters who were not able to get benefits because of prior penalty week determinations that they had to serve out before they could obtain any benefits. And as I recall, that tool was what the department had to, sort of prosecute, if you will, these people who were trying to fraudulently use the unemployment system. And I honestly wonder that myself, Senator Brock. How is it that someone could defraud the state for $100,000 and not be prosecuted? I don't know how that didn't happen. It seems to me that that person absolutely should have been prosecuted. So I guess that would be my answer, that I think the reason we haven't seen more is because the department was relying on the penalty weeks as the sort of punishment for any attempts at fraud, and saw that as the vehicle for doing that.
Well, one of the issues, as I gather from the testimony we've heard from the department previously, is it was under the impression that the legislature had repealed the laws relating to criminalizing fraudulent behavior, and therefore they had no mechanism to proceed. And as we were looking at how to deal with really egregious cases of fraud, there are other fraud statutes that may be applicable provided somebody prosecutes. Now, I know you've raised the issue that there are lots of people who make mistakes, and that there is a long process involved in which those mistakes are adjudicated. But the issue of going after fraud criminally would only occur after all of that was over and a determination had been made through all the various appeals within the department that fraudulent conduct had occurred. And then only in cases that rose to the level of a felony would the potential of criminal prosecution be considered. Do you think that not going after people criminally who commit fraud of that nature is something that ought to be public policy?
First, I would say that I was not aware that that the fraud prevention amendment was going to be limited to cases that would arise to a felony level. Maybe the draft that I saw,
yeah, that's right. You
didn't
looked
have
at
that.
an earlier draft, and the current draft does that, and it lists the minimal amount at $900, which is consistent with how fraud is defined for other insurance purposes.
I certainly don't do any criminal work, and so I'm really not at all familiar with the fraud statutes, but I, in talking with colleagues, understood that there would be some provision in the law that would allow a referral for prosecution in cases of fraud against the state, regardless of whether it was in the unemployment context or some other context. So, but again, I'm sorry to say I'm not really familiar with those statutes. I do believe that egregious, as I say, there's no doubt that when someone defrauds the state for any amount of money, they should be prosecuted. The issue that I have is that there is a difference between misrepresenting something or failing to report something and committing criminal fraud. The intent and the degree of proof necessary to prove that intent is much higher in the criminal context. And I think what happens more often, and I would say everyone, well, I guess I can say I've probably talked to several hundred Vermonters in the last year about unemployment. And before that, before COVID, I was doing unemployment work as well. Of the years I've been doing unemployment work, I can think of one person that I was pretty sure was not above board in terms of what he was trying to do. And I obviously wasn't able to help him at all. But almost every other person doesn't understand the very complicated rules involved around reporting things to labor, applying, how you fill out your weekly claims, when you're eligible, when you're not eligible. The rules are very complicated. That's what we see. And that's typically what results in a finding of intentional misrepresentation. And the other piece I would add is that there is this claims adjudication process at Department of Labor. But very often, if claimants are having any sort of a reason why they're not responding to email, they didn't get mail, claimants are often left out of that determination that says that they intentionally misrepresented or failed to report something. The adjudicator will make an effort to reach out to the claimant, maybe once, maybe twice, but if they don't hear back, they will just make a decision, and the determination says, based on the available evidence, we find that you intentionally misrepresented or failed to report something. If the claimant then, and we see many of these people who, for whatever reason, they do not have the bandwidth to appeal that decision. There's only 30 days to appeal that decision. On the 31st day, you are out of luck, except in extremely rare circumstances. So I could give you a list of people that we saw, particularly at the beginning of the pandemic, who were found to have intentionally misrepresented or failed to report something, did not appeal those decisions. And as we talked to them about the facts of their case, we felt certain that they had a meritorious appeal that would have been reversed had they appealed years ago. There was really nothing for them to do at that point, so they had to just serve out penalty weeks. But this is so the issue is, I think that many people are caught up in that first adjudicative process at labor and swept into the intentional misrepresentation group simply because they didn't participate in a fact-finding interview, or they didn't understand something that they should have done. And that's our fear, that the processes that are there really aren't enough to ensure that those people referred for prosecution are going to be just those most egregious cases that have in fact gone through a robust fact-finding process involving the claimant at the Department of Labor.
How would you tighten up the definition of what gets referred for prosecution so that it clearly does only focus on those who have intentionally and willfully misrepresented critical information and the department is aware of, and that there has been a robust review before the decision has been made to prosecute? How would you better define that in order to focus on those particular cases?
I guess I would say what I would do is to improve the adjudication process first at Department of Labor. And I would do that by increasing the number of claims adjudicators that are available and training them much better, a much more robust training program that involves not only education about the complex rules at the Department of Labor and the unemployment statutes, but also basic training in how to work with human beings and how to work with people over the phone or in person. And then I would also require that any conversations during these adjudicative proceedings be recorded and available to the claimant so that on appeal, they could be reviewed. I think that's a key piece that is missing here, that if the department or the legislature wants to rely on those determinations of the claims adjudicators, that process needs to be improved. Due process is missing from that. Claimants are often denied a meaningful opportunity to be heard by the claims adjudicator. I have a client who was an outdoor educator, had applied for unemployment, was outside. I don't recall doing what at the time, that the adjudicator called and left her a message and said she had 6 hours to respond or they were going to make a decision. She had to run up a mountain to get a cell phone signal in order to be able to call the adjudicator back, never spoke to the adjudicator, left a message that apparently was not considered in making the determination. And she received an unfavorable determination. So
Yeah. Well,
that's not due
absolutely
process.
understand the issue that mistakes can be made, that people can have misinterpret, people cannot understand regulations, and that's not what this is intended to. This is
Right.
intended to deal with a situation in which someone has invented an employer or invented a history of work that did not in fact occur. It's
Mhm.
designed to focus on the out-of-state groups of people who in organized fraud rings are attacking systems all over the country in the increase in fraud of this nature that has occurred during COVID. That's what this is intended. It's not intended for the person who made a mistake or who left something out of an application. And
Mhm.
what I'm looking for is, and that's why the issue of better training examiners is not going to pick up those differences. The differences are much more concrete and easily observable. But a prosecutor presumably makes the decision as to what's appropriate to prosecute, and this is only the last in a series of steps after the department has completed its review to determine whether or not something is and I'm absolutely open to considering better ways that you or anyone else can suggest to hone in on that population, which is what this amendment is designed to do.
Mhm.
Again, I realize we unfortunately are pressed for time. I realize we could perhaps discuss this offline in more detail, but Mr. Chair, I know that you want to move on to the other issues that we have on the table here.
I do, and I just want to appreciate that, Senator Brockton. Appreciate your testimony, Kelly. I, you know, maybe this issue is ripe for adding to studies if we get that far. But I think there is a danger here of sweeping in more than we want here and not really targeting the people we want to target. But that's what I sort of tried to express yesterday, where people were unaware of what was going on. So, Cameron, could you just briefly comment on all this, on how you view the department's laws right now, and whether you think they need fixing, and what kind of burdens that might put on you, and how we compare generally to other states in this area? Just an overview, and then we'll wrap this up. Maybe we'll come back to it later this morning, but go ahead.
Yeah, good morning. For the record, Cameron Wood, Unemployment Insurance Division Director for the Department of Labor. There's a lot here, I think, to try to respond to. I definitely, I hear and I understand a lot of the frustrations that are experienced by a lot of individuals out there. We also have to recognize that we have to administer a program and we have to administer the division, and we can't, as you all know, this is not a very easily understood program. It is not something that is either easily communicated to claimants. It's also not something that is easily understood by our employees in a lot of instances. So I recognize, for example, the comment of trying to train more staff and train them better. And I think we're always in a position where we want to do that. It's also very challenging when we hear, coming into committee that, the phones need to be answered and people need to make a decision and move on. We can't hold cases open for, an indeterminate amount of time to be able to make a determination on the claimant's time. That's why we have a 30 days for appeal. That's why we have to set deadlines for people to get back to us. If there's a scenario where somebody called and said, you got 6 hours to get back to me, I mean, I would find that to be wholly inappropriate. I would also question whether there had already been outreach to that individual to provide a response, and whether the individual had not responded to the initial outreach. I mean, we've had to do a lot of things in an unorthodox manner to try and address this pandemic. I mean, everybody keep in mind, we were hit with 100,000 individuals trying to get benefits all at the same time. And we were woefully unprepared for that because we didn't have the staffing levels necessary or the funding levels necessary. So, I mean, I want to, Mr. Chair, I think you're wanting me to address a few other things, but I just wanted to take the initial moment to say we are always trying to do better. We are always trying to train our staff better. It's not a situation where, I don't want the public perception there to be that our staff don't care, or our staff are not trying to make the correct decision on these cases. In a lot of instances, it is a circumstance where we're trying to be able to move a case on so we can get to the next person. I mean, if we have a backlog of, 5,000 people waiting, we can't just allow someone to hold up their case and just let it sit there. We have federal performance measures that we have to meet. And so, there's a lot that goes into that. Do I think so? A few of the specific topics there. I think Kelly is correct. We don't have any fraud statute to refer from. So when we determine there to be an instance of fraud, and it is, if somebody has intentionally misrepresented themselves, the only recourse or punishment that we have at our disposal is a 15% penalty, and then adding penalty weeks onto the claim. There is the possibility of adding an administrative penalty of up to $5,000, but as the committee's kind of talked to here, we don't have the resources to do that. Keep in mind that we are federally funded, and we receive no administrative dollars from the state, and we are woefully underfunded and always have been since I've been here. I think our budget, I did a calculation to give it to USDOL before the pandemic. I think our budget had been cut by, it was like 10 or 15% in the few years that I have been here. Pre-pandemic.
Let me interrupt, Cameron, because we're going to have to wrap this up. I thought I heard Kelly say that there was the ability to, in egregious cases, to forward that on to somebody. And the other thing that I wanted to mention on that is I think we heard from, it's one of these hot potatoes where both the state's attorney said that's not our job or we can't do it, and the attorney general said that's not our job and we can't do it. So we don't even have an agreeing agency at this point to accept these referrals. But what is there an ability for these $100,000 or scam things to be prosecuted, or there's no authority at all to do that? What's your understanding?
I don't mean to further the hot potato here, right? But I am not aware of any statute that we can refer these cases under in Vermont. It is but I will also echo Kelly in saying I'm not a criminal attorney. I don't practice criminal law, so I don't know what could be there or what we could refer possibly under. It sounds like Senator Brock, if you've had conversations where there's some potential room for interpretation of some criminal statutes. Again, we don't prosecute anyone criminally here at the Department of Labor, so it has to be referred to either a state's attorney or the Attorney General's office in order for them to do a criminal prosecution. And if I would have to defer to them as to whether there are statutes currently available to do so.
Let me just interrupt for a second, because you don't have the latest copy of the amendment. And what the latest copy of the amendment does and this is after alleged counsel, I believe, spoken with the Attorney General's office, at least initially, is that if the AG isn't doing it because of where their resources, and refers to state's attorneys who claim also to be under-resourced, under-trained to do it, the latest amendment adds an assistant attorney general housed in the department to focus on both fraud and on overpayments and overpayment recovery. And it's not that we're dealing here with small amounts. At least the calculation I've seen, and Cameron, you can perhaps confirm this, that between FY10 and FY19, Vermont had overpayments amounting to $55,473,000. That's a huge number. And then if I look at between Q317 and Q320, the UI Trust Fund made nearly $6 million in overpayments, some of which were blatant fraud, but recovered just $2 million, suggesting that 2/3 of overpayments went unrecovered. According to some statistics I have, Vermont paid out more fraudulent overpayments alone than it received out of all UI overpayments in total. And that's what I'm trying to get at with this amendment. And if there's another way to do it, but counsel has advised that there are fraud laws on the book, particularly for these egregious cases, which is what I'm most concerned about, that can in fact be used, that are already on the books. We just don't have anybody doing it.
Yeah.
And I'm suggesting here that we have somebody doing it, and particularly since some of these are directly related to increased fraudulent activity during the pandemic, that we look at federal one-time money at least on an interim basis. This is not a permanent ad, to provide what needs to be in place in order to go after these things. And yes, we do need to do more work to be more precise about what we're looking for, because I'm not intending to gather up in some dragnet people who just make mistakes.
So
Okay.
real quick, I'll make a few quick points. Senator Brock, I think your numbers are probably correct. I don't have them in front of me. I will say we here at the Department of Labor have one of the best, or pre-pandemic, I'll say we had one of the best improper payment rates in the country. I think we were only down to around 3 to 4% of the payments that went out the door were deemed to be improper. However, when you get to just the sheer volume of payments we're talking about, it gets into the tens of millions of dollars, as you've identified. So yes,
well,
I think
the point that I make though, Cameron, is yes, the overpayment rate is lower than the US average, but it's also 5.3% lower than New Hampshire's recovery. This is the recovery rate.
Right,
and
right.
Our recovery rate is 43.4% lower than Maine's.
Right. And that's where I was about to get to, Senator Brock, was that we had prioritized it or identified it as a priority area prior to the pandemic of trying to explore ways that we could do better from a collection standpoint and a prevention standpoint. Unfortunately, the pandemic has put all of that efforts to the side. I think having some additional resources dedicated to this could help. There's a lot of rabbit holes we could get into when it comes to this conversation, because I do recognize on one hand, there are individuals who are fraudulently receiving benefits. And then on the other hand, there are a lot of individuals who are in circumstances that Kelly works with and that she's identified. I think the approach and try and tackle those two things is a little bit different. And so I think, Senator Brock, to your point, having some additional resources, obviously we're going to try and prioritize the situations where, they are higher instances of fraud, or there's a higher dollar amount that has been overpaid to those individuals. But, we can't just ignore other instances as well. So I think resources would be a benefit.
I'm sort of losing control of the time frame here. So you ask a quick question?
No, my quick question is, it sounds like the department needs so many staff at the moment.
Yep.
It strikes me that what you're saying is this is not a priority of staffing for VDOL right now.
Mhm.
And is that what I hear you saying?
Yes, ma'am.
Yeah. And that we would have to add a staff member to this bill for it to be even feasible for you.
Yes, ma'am. So typically we only have, for example, we only have one collections attorney here at the department, and that individual is spread across, multiple programs. And so I think having additional resources who could be dedicated to this would be a benefit, because it's not a priority for us. We usually have around 3 staff members, 3 FTE, who are dedicated to recovering overpayments from claimants and employers. All of those individuals have been reassigned at this point, because we have other areas, including fraud prevention, trying to prevent the fraud from happening. One of those individuals has been fully reassigned to doing fraud prevention. So we try to prohibit the fraud from happening before it does. But yeah, we don't have any resources dedicated to any recovery activities right now.
Thanks. That's helpful.
Senator Rahm, briefly.
I'm hoping this is helpful. Senator Brock, I think we share a common interest in understanding how UI modernization will impact all of these issues. I mean, we've heard from other states that as they modernize, it's opened more doors to fraud. And I think that's really where we should be putting our energy, is when we modernize, how do we look at other states and the work they've done to close those doors and those loopholes? And I've been trying to work offline on understanding the modernization effort, understanding what other states do. And I wonder if we could put our energy there, since we could put a lot of work into something that becomes kind of irrelevant, as we try to modernize our UI system. So I'd love to keep working with you on that.
Well, I would agree. At the same time, if you look at the numbers of money and the amounts that are going out, and also the clear national implications of the avalanche of fraud that's occurring during COVID, doing nothing now while we study it is not an option. And in the update of the amendment, I have added resources, a resource to be able to deal with that. And the resources also are designed, assuming we can do so, to be paid for with one-time money, so they're not there permanently. But at the rate that we are losing money, we're losing more money than many of things like benefit increases we would want to make would cost.
Okay, let's take a pause on this issue. We're not going to resolve it right now for sure, though. We'll see if we have time to get back to it. So what thank you, Kelly, very much. Thank you, Cameron. Cameron, please stick around if you can.
Yes, sir. Yes, sir.
So what I want to do now is, there are a couple of areas, which this is not a secret, that Senator Brock and I have been working on, that I think we've come to narrow the issues in disagreement. And I'd like Damian to walk through an amendment that I asked him to prepare, and the thorny sort of issues at this point deal with not so much the tax reductions that are being offered in this bill. Some people would take an objection to the word reductions, but we're trying to fix that as well. And not focus on the benefit enhancements, which seems to be an area that we still have not reached a consensus position on. So Damian, if you could pull up what and he has several drafts for me. Senator Brock, if we go to the floor today, is your amendment in final form? I mean, we would need to, the committee would need to take a position on your amendment as well as my amendment. I have several versions, so mine's in final form, but do you?
It's in final form. I think I need to do a final review with Cameron, because I got that amendment late last night, with Damian, because we have not had a chance to discuss the final version of that amendment as yet.
Okay. Would you be willing to offer that a third reading if we went forward today?
If we went forward, I would consider that.
Because I just don't know, without the final version, I don't know that on my amendment, which you'll see, committee has to vote on it. And
Yeah, obviously I haven't, have you sent your amendment out, your final version of it?
I have not. I barely saw it this morning as well. So,
Yeah, you basically have
but
this,
I
have
think,
the same issue that we both have amendments on the same thing that nobody in the committee has seen.
Well,
right. Well, that's what I'm about to do, at least with,
about-
a significant part of my amendment. It really, I think both your and my amendment are not going to be that much different, and they're not that complicated, but you're right. We do need to see it. So other than the benefit thing, which is still at issue, which I don't want to focus on, the amendment that Damien's going to present tries to do a few things. One is it limits the tax reduction just to FY 22. It creates a study that Senator Brock and I are calling to try and get to right size the trust fund, to bring a report back before next session so we can work on that. And, it's in some ways, the decision just to do the first year of the tax reduction is very similar to what we faced last September. We don't have to make the second year decision until next July or a couple of months prior. And if we're going to be doing a thorough review of the whole trust fund, it doesn't seem to make sense to get out ahead of ourselves, even though the committee's amendment from a week ago or so did do both of yours. It tries to meet the concern that and Senator Brock and I have gone back and forth on this. I don't know how legitimate it is, but it's certainly worthy of consideration to make sure that the tax relief that we're giving to businesses is really tax relief and not just a loan going forward. And then the third part of the bill, I'm trying to think, it is a study, as I said, for next year to right size the fund. So if we could talk about those changes, Damien, that would be helpful. And let's hold in abeyance any discussion on the 20% and the permanent dependency benefit at this point.
Okay. Oh. Good. I'm unmuted. I thought I was muted for a second. So I'll start with let me just share my screen here. And so I've skipped right past the benefit language to the rate schedule. So as Senator Sirotkin mentioned, this just freezes the rate schedule at Schedule 1 for the year beginning July 1, 2021. And the second year of that is taken out. It adds in language here that would address the long-term rate impacts on employers. And so this language is session law that if there were long-term adjustments made to the trust fund next year, this could be repealed. But what it does is it would direct the Commissioner of Labor to reduce the amount of unemployment contributions made by employers during the 10-year period beginning July 1, 2022 by a total of $66.5 million. And those reductions would have to be distributed across the 10-year period. And then among all employers who are liable for payments of contributions. And then, I'm sorry, this is slightly old language here. And I apologize for not getting every update into this draft here. It would be through a proportionate reduction in rates for each rate class, any other proportionate reduction in contributions, or any other means of proportionally reducing contributions for employers, provided it's permitted by federal law. There are restrictions in federal law that prevent you from treating certain employers differently from other employers, except on the basis of their experience rating. And then or some combination of the three could be employed. And so essentially this would allow the commissioner to notwithstand the existing tax schedule and make adjustments on it to reduce those contributions. And by pushing it out 10 years, the idea is that it would continually be adjusting down the contributions until such time as the current funding formula would not be taking 2020 into account anymore. I think, as I mentioned before, this could just be repealed if the legislature adjusts the funding formula in a better manner next year after they get additional information on the appropriate balance for the trust fund and have a chance to weigh different means of achieving that balance through adjustments to the funding formula and benefits and other aspects of the UI program.
So, do you have that other language, or can you explain the additional
I
language?
do
I have
have that other language. Just give me a second to pull it up.
while David was doing that, I just want to say that I was open in to the extent this mechanism is somehow flawed. I assume that the House with more time could figure it out, but the goal here is clear. So I asked Damien to draft a fourth option that the commissioner could come up with another way of achieving this goal if that makes more sense. I think it should be run, probably it should be run by stakeholders before it's implemented, but I want to give the commissioner flexibility to achieve this goal, which I think Senator Brock and I agree to.
We do.
So this is the updated cost avoidance language. I've just added this subdivision 3 here. So it just says any other means of achieving a reduction in the contributions that is permitted by federal law. So it just, to the extent that there may be some means that's not a proportionate reduction in the contributions, but can achieve this spreading out of the contributions. So maybe that's a reduction in the taxable wage base or something like that. This gives some that flexibility. You'll notice it notwithstands any provision of 21 VSA Chapter 17 to the contrary. So that's the whole unemployment insurance law, and this should give the commissioner flexibility to make adjustments to the funding mechanism because it's spread across several sections of that chapter. And so I wanted to avoid inadvertently tying the commissioner's hands here. The department has seen this morning. I don't know how much time they've had to review it. And I have not received any feedback from them on it. They received it minutes before our hearing this morning. So other questions on that?
I really appreciate your mentioning the taxable wage base. I hadn't thought of that as another alternative to reduce contributions. So I think, where there's a will, there's a way, that it can be figured out to get us past that 10-year period when the 2020 thing will drop off the charts. And I'm very sincere in trying to. I'll say again, I didn't think, because there's so much uncertainty in the out years, that this wouldn't be a permanent benefit, effectively a benefit to business, but I appreciate their concern, and it was my intent pretty much all along to give them the tax savings. When they came in last year saying it was going to cost $36 million to go to Schedule 3, no one said it was a phantom tax cut, that it would be recaptured in the future years. So I guess I was working under that presumption all along. So,
I think we all were. And Mr. Chair, if we can add the taxable wage base, that's worth about $3 million. Is that right for the first year?
According to Damien, that this is the right number for both.
66.
So I believe so. I have been scrambling this morning, so I haven't had a chance to double check with Matt on that, but I can confirm that here. So it's, but I
Right.
believe based
Right.
on my chart, that's the right number. I just need to go back and check my work on my chart.
Okay, my understanding is that, according to Damien, that includes the freeze in the taxable wage base. But if
Okay.
it doesn't, the taxable wage base has been priced out at $3 million. So that number would have to go to 69.5 if it doesn't include the taxable wage base saving.
Thanks.
Okay, let's move on.
Okay, so the next piece here, we're just renumbering this section. And then the final piece in here is just the effective dates. The changes in here related to the benefits because of the way the sunsets are set up. So depending on what you do with benefits, that's going to affect how these effective dates are. The only thing I would note is that because of the late hour here, lines 14, 15, and 16, we've added new language, and this is in Senator Brock's amendment as well. It says that provided, however, if the date of passage is after March 31st, then section 3, which is the extension of the sunset from last year, which occurs on March 31st, would apply retroactively to that date, just so we don't have a bizarre situation where people are no longer qualified for unemployment because they quit for a COVID-related reason and then they requalify 2 weeks later. So that's what this language is designed to protect against and to prevent the department from having to go through and reassess all of those claims 2 more times here. So that language is in. It's also in Senator Brock's amendment. So regardless of what happens on the floor, that language should be in.
So does that take care? I know people who are on unemployment that bridge over March 31st, they'll continue to get their benefits. But people who apply, let's say they get COVID on April 4th and they have to leave work, would this protect them that it would be applied retroactively so they would get their claim adjudicated favorably?
The intent is that is that this would protect them. Cameron is really better suited, though, to speak to how their claim would be processed if they were applying on April 4th and this was, for example, still sitting in the House or something like that. So
I know that there could be some danger here to newcomers. Hopefully there are not too many, but I guess what I'm asking is this language sufficient that eventually they would get their benefits?
that is the intent. And I again would just defer to Cameron to talk through that process, but I believe that this would allow the department to go back and make a determination on that claim that they were in fact entitled because the law extended through. So I think Cameron is still with us.
Cameron, do you want to speak to this?
Yeah, I talked to Damien about it just very briefly yesterday. I mean, officially speaking, if the language is not in effect at the end of after the end of March, then those individuals would could be denied unemployment. If it's made retroactive, we would need to try to track them. I'm not saying that it's not possible. It will obviously be a challenge for us to try to keep track of them and administer it.
Can you work with Damien to see if you could come up with some language? I mean, we may have to do, depending upon the process today. I mean, I guess if we could give some direction or allowance to say, you know, while this is pending until, you know, April or end of April or something, you can delay adjudication or something.
And Mr. Chair, I think your language is fine here for what you're trying to accomplish. From my perspective, if it lapses on March 31st and it's retroactive to there. So I don't know that I would change the language, and obviously I defer to Damien, but I think for what you're trying to accomplish, I don't think there's any need to change the language. And I think I haven't had a chance to circle up with the commissioner to talk about this, but we obviously don't want to create any unnecessary additional work for ourselves, and we want to recognize that the circumstances of these individuals and this bill going through, but we will have to just try to balance those two things if the language is not in effect anymore, because we also don't have a guarantee that this will pass.
Right, but that's why I'm saying the legislature maybe could say that all people that fall into this hole or this gap, you have the authority to delay a determination on, and to a certain date. So you could write them a letter. I don't want to see people who are likely to get retroactive benefits getting a letter saying they're denied and have to appeal or reapply. It's just going to cause havoc. It would be better if they got a letter saying, we're waiting on a decision from the legislature. You will hear by such and such a date. And I don't know if you need language to do that, but I'd be more than happy to put that in.
The only way to do that statutorily is to pass something. So if that language is still pending in the legislature, it puts them in the same position. They can't rely on it passing until it's actually passed.
Right.
So that's the problem, is they have to implement the law as it's on the books. And if it's sitting in the House, or if it's on its way to the governor but hasn't been signed yet, then they can't implement the law. So if there is a vehicle to move that section alone right away and get it to the governor before the 31st, that's the easiest way to ensure that there's just no lapse.
Right.
Because that's the language that has an expiration date on it. Everything else, the rate setting for next year also has an expiration date that's coming up very quickly, but that language in particular is going to affect people's benefit payments. So that's the issue.
Okay. Even without a separate bill passing to accomplish that, I would think the commissioner would have the authority in any communication with a new claimant who had a COVID-related claim to write a paragraph saying what's going on in the legislature and help them not get freaked out, or have some hope anyhow if we can't pass a separate bill on that.
And just, Mr. Chair, real quick, it's not going to impact anyone who's currently filing.
Right.
And I think, like you said, I mean, presume
their determination is good for as long as they are filing, right?
They are good. Right. This would be anyone new. I think, Mr. Chair, you kind of mentioned, hopefully, I don't anticipate there being a lot of individuals in this situation, but again, like I mentioned, I think the department was supportive of that provision in the bill. And so we want to see that move forward, just like the other provisions that we support. So I think we'll try to do the best we can to ensure that these individuals aren't negatively impacted by any delay.
And Damien, I'm sorry, but your language, could you email it to us or get it to Nathan? Because I can't go back and look at the sections that I can't look at it. Your language.
I'm sending it to you now.
Oh, thanks.
Yeah.
So wasn't there also a section on studying?
I was gonna ask.
Yeah, the trust fund task force we need.
Sizing of the trust fund.
Yes, there is. I'm sending you that as well, and I'll pull that up on my screen in just a second.
Okay, great. Thanks. It's just helpful for us to
Okay, so I just sent that to everyone. Let me just reshare my screen.
It's just hard to read for those of us who are as blind as we are.
I understand that.
Oh, you're good.
So there we go. So this is the assessment of the current funding mechanism. So the what this language would do is it directs the Joint Fiscal Office and the Commissioner of Labor to conduct a review of the solvency of the UI Trust Fund during the period since January 1, 2000, and the impact on the trust fund of the statutes related to unemployment insurance contributions and benefits, and any changes made to those statutes during that period. The review would include an assessment of the amount necessary to ensure the continued solvency of the trust fund during a future economic recession based on the economic cycles that were experienced by the state since January 1, 2000. It would then direct JFO and labor to convene and consult with a working group composed of representatives of employers and employees, economists, and other persons with relevant knowledge or experience as determined by the Joint Fiscal Office and Commissioner, and then to report back to this committee and its House counterpart with their findings on or before November 15th. You'll notice that one thing this doesn't do, and which it is make a recommendation for a new funding formula. And the reason for that is that the Joint Fiscal Office, like Legislative Council, we're restricted from making a recommendation as to the policy you should adopt. We have to remain neutral on that. It doesn't prevent labor from separately submitting a recommendation, and it doesn't prevent the legislature from saying to, for example, Leg Council on November 15th, I like this model here. How do we draft the formula to get there? So that is all still on the table. What this does is it gives you the background information you need to figure out, okay, so we've got our solution. What's the formula we're going to use to get to that solution? And this also acknowledges that that formula, depending on which member of the legislature we're talking to, may feature some combination of enhanced benefits and decreased contributions, or it may focus on one or the other categories depending on that member's sort of policy goals and so forth. And so again, that's what this is doing here. Is it's giving you the final answer for what the balance needs to be, and then allows the legislative debate for how to get there to occur next year.
Great, right.
Okay.
That's
So there was one other change that I've been public with that I think is a fair improvement upon what we did, and that is to start the benefit enhancements, be they the 20% or the permanent dependency benefits that we voted on Labor Day as opposed to July 1st. We originally proposed July 1st because that's when the tax reductions were going into effect, and the unemployment system being in a quarterly system. But given that they're new benefits, I think they can start on any day we say. And so there's, I had no objection to the fact that they get delayed for 2 months to deal with the fact that as of now, at least, the $300 is scheduled to sunset or end on September 6th. Is that incorporated here yet, or did I not communicate that with you?
So if you'll look at the effective dates on the amendment,
okay. So
the
which page
benefit
is that?
changes take effect on September 6th, 2021. So
Okay.
that is incorporated. I have 2 other amendments that affect the sunset and what benefits come out, but all of them include the September 6th start date.
We
Okay,
had language, I know in my amendment, I don't know if it's incorporated anywhere here, that starts the additional benefit when the federal benefit ends. We know right now the federal benefit is ending on September 6th, but if that benefit is extended, would these new benefit rates continue so that both would be paid at the same time?
Senator Brock, I have no objection to that change.
yeah, I think that's important for us to have it sync up with the end of federal benefits.
Right.
Whether
I just want to make sure whether it was, I didn't see it in this amendment, although we're going through it very quickly, and I know we've discussed it previously, and I just like to make sure it's there.
The only objection I have, I think, no, I agree with you. It should start because one of the goals here is to soften the landing, so to speak, of people from the federal $300 being removed. So I don't disagree with that. I think your language, though, had an endpoint that if it didn't, and that may be because we were talking about 1 year back then, but
Yep.
you had an endpoint that it may never, these benefits may never go into effect if the federal government continued them for another year or something like that. So given the
Yeah, we certainly had a difference in terms of the permanency
right.
of the benefits.
Right, okay. So if we can make that change, Damien, the effective date should be September 6th or whenever the Federal Recovery Act disappears or something.
Sure, I can do that. A lot of it's just going to depend at this point. I have 3 different versions depending on which benefits enhancement you want to go with. So is this the appropriate time to discuss those, or?
Not really, but
Okay.
why would whatever benefit we put in, why would the effective date not be able to be changed?
I just want to make sure that it's easy to put in. I just want to make sure I put it in the right draft, or if I need to, I can put it in all 3. It's just, I want to make sure that I don't inadvertently give you a draft for the floor that is missing language.
Okay.
Does that make sense?
Yes.
Yeah.
It does.
So, yeah.
So what I think we should do at this point is we should take a half-hour break, figure out where we're going, and I definitely owe the pro tem a decision on whether we should move forward today or postpone till tomorrow. I don't want to postpone tomorrow if we have no hope of changing anything here. But that will, I don't know, Senator Brock, just to be forthright, I haven't had a chance to talk to others about our discussion. I don't know if you have yet, but
Very limited.
yeah,
Very limited.
I need to do that.
And that's, I certainly think that we both need a chance to have those conversations.
Okay.
I realize that there's an imperative to get this done, but I'm very concerned as we're making changes on the fly here, and folks really have read your changes just now. I think we need at least a little bit of time to digest, and I realize there's not a real desire on anybody's part to prolong this, but I think a day to finish these discussions, to finalize the draft so we know what we're dealing with, and then be able to understand what we're voting on, and at least hear from constituencies that haven't seen either your piece or mine at this point. They need a chance to be able to react.
I hear you. Okay. And so you and I will probably also talk within this next half
Yep.
hour as well.
Absolutely.
Okay. Thank you very much, folks. We'll see you at, why don't we say 10:15?
Time out there, because there's like a joint assembly. I just want to.
Oh, no.
Yeah.
What time?
That's another reason.
Allison, you're on mute, but I think it's at 10:30.
it's at 10:30.
Oh, my Lord. Okay.
And
Well,
it's,
certainly it would be a real up mountain climb to try and I mean, basically, we would come to a standstill once these amendments are presented on the floor because we don't have committee positions on them at this point. So it looks like I'm going to tell the pro tem that we have to wait a day, and I trust the words of my peer Senator Brock that he's sincerely interested in moving this along and getting this.
Ma'am, if we can.
Okay, thank you.
So are we still trying to come back at 10:15?
Let's come back at 10:15, and